Good afternoon. This is attorney Talib Karim with Abe Legal. I'm really happy to be joined by um, an outstanding attorney all the way from Alabama who has some extremely wonderful experiences as one of the youngest, first of all, directors and founders of uh, the public defender's office down in Alabama, and she's going to be sharing with us some of the experiences that she had in that post, as well as what she's doing currently to defend the rights of workers who believe that they have been wrongfully terminated, either result of race or ethnicity or gender or their faith or other factors, as well as federal employees. And what are some of the unique challenges, particularly during COVID? If you have any questions to ask our special guest legal analyst, attorney Kyra Fonteneau, or if you have any comments that you'd like to share, please drop them into the comment section, and we will look forward to getting to those questions and our comments. If you want to make sure that you catch the latest of the updates on some of the exciting legal developments, especially during the current administration, don't forget to subscribe and like this comment or this program, and feel free to share it with your colleagues. We're looking forward to putting again together a series of these really exciting and provocative conversations on a weekly basis. And so, without any further ado, let me introduce to you attorney Kyra Fonteneau. Kyra, how are you doing? Add to stream. First of all, let's do that again. Kyra, how are you doing?
I'm good. Thank you for asking. How are you?
Yes, great. So first of all, I alluded to the fact that you were broadcasting or with us today all the way from Alabama. Where exactly in Alabama are you, and how is your family? I know that we're in a really challenging situation with COVID. How are things there with you?
So we're actually really great. I'm in Birmingham, which is about 2 hours from Atlanta, about 3 hours from Nashville, in the north central part of Alabama. And we've been doing amazing. My family has been luckily not touched by COVID in any severe way, other than the fact that, my 9-year-old wasn't able to go to school for a while. But other than that, we've been doing really well.
Excellent. I'm really happy to hear that. So, Kyra, let's go right into some background about you, and then start talking about some of the questions that we've already began to collect. A lot of workers are really concerned about what's happening now with respect to their employment, and a lot of folks, have been challenged even before the pandemic, and now with the pandemic, it's just increased the challenges. So let's talk a little bit about where you come to this conversation from in terms of being an expert in both employment law and civil rights law and federal employee EEO, as well as Merit System Protection Board issues. So let's talk a little bit about your background. I understand that you actually were born in Detroit, but let's kind of do a quick summary of where your background. We'll put up on the board our kind of tear sheet on attorney Kyra Fonteneau, and take my ugly mug off the screen and put hers on there. But can you just walk us through your background, attorney Fonteneau, and let us know your experience.
So I, as you said, I am originally from Detroit, and spent some time in my youth there until I moved to Hawaii, then back to Detroit, and then moved to Virginia and finished high school and college there. I went to the University of Virginia, which is in Charlottesville, and after that, I moved to Atlanta, and for several years, I worked in banking. and then realized that I probably had a better calling as a lawyer. And so I went back to law school and went to the University of Georgia. And when I left there, I got a job in Alabama, in Birmingham. I never set foot in Alabama before I got that job. And I was at that time representing employers in disputes with their employees. So I started off doing employment law. I knew I wanted to do employment law when I went to law school. And so it was a lucky break that I got a job here doing that. Did not enjoy the people that I was working for. And about 18 months after that, just left and decided to start my own law practice. And then after that, I was a general practitioner, and I did employment law as I could get it. And then I did a lot of criminal law as well, and really developed a love for dealing with regular folks who are going through it. And represented criminal defendants for a long time, and had an opportunity after I started practicing for about 8 years to start and run the first public defender's office in Jefferson County, Alabama. So a lot of people think every place, if you come from another place, you think every place has a public defender's office. They don't, particularly here in the Deep South. And so got the opportunity to do that and built it from the ground up. Really took some guidance from public defender leaders all over the country and built a model public defender's office for the state of Alabama, which has actually been replicated in a few other locations around the state. We're now at 2 other locations around the state. But as politics goes, I got fired, which happens to a lot of people, and after I did that, I had to kind of do some soul searching about what I wanted to do. And I still wanted to help the same population, but I also remembered, how much I really enjoyed doing employment law. And since then, I started back with my own firm and built it back, representing solely people who have been harmed by the government or by their employers. And so I take, only cases for employees. I do not represent employers. And we try to make sure that they get justice in the workplace. And so I know what it feels like to actually have gone through being fired. I know the emotions that you feel. Unlucky for me, when I got fired, it was like on the news. So I really know what it's like to go through that process. And so we really try to walk our clients through the process, understanding the emotions and the uncertainty that they're going through when they lose their jobs.
It's interesting that you say that, because there's oftentimes a disconnect between lawyers and those people who need legal services. And one of the things that we are doing at Abe, and that is really recruiting to our team world-class lawyers who have experiences that they bring to legal representation that people might not ordinarily be able to find. And with that, I understand that you are backed by a team of lawyers who assist you in your firm. How do you kind of communicate that sensitivity to some of, let's say, your colleagues or junior lawyers, so they can really be able to, let's say, conduct a consultation or engage with people in a way that folks will really feel like they are being heard and that their legal issues are being addressed?
Well, and that's key, right? Because if you lose your job or you've actually been harmed for the police, time is of the essence, right? You're not in a situation where you can not act on what has happened to you. So like, say it's an employment case. If you if you've been discriminated against, you have very short time frames to which you can complain to the government in order to get that resolved. Same with a civil rights case. Oftentimes, there are very short periods where you have to make a claim with the city in order for you to preserve all of your rights. And so the first thing is to have sort of a sense of urgency about what it is that we're doing and what's important to our clients. And then we also kind of advise them about what they need to do. Oftentimes, when you have sort of a car wreck or something, the damage is already done. You're just trying to rehabilitate and get your body back to work. But in an employment context, you're trying to put your whole life back together, right? Because you are uncertain about how you're going to pay your bills. You're uncertain about how that's going to affect your kids' childcare. You're uncertain about how you are going to, live. Where are you going to live? Because if you don't have the money to work, from work, then you can't do all the things that you need to do, including healthcare. And just losing your job can actually just kind of send you into a spiral that can take years to resolve. And so the first thing that we have to talk to our staff about is understanding why the person who's calling is so frantic, why they're upset. I know when it happened to me, there were days when, 3 or 4 days went by before I could even, register the gravity of what was happening to me. And it was a year before I fully recovered from losing that position, even financially or even mentally. And even now, to be able to talk to people about it, that it's stigmatizing to think you've been fired. And so I think it's important to understand that people are grappling with important emotions, and our staff understand that as well. So they're going to listen. We have people who are on our phone system 24 hours a day, trying to get information for people, because we recognize that there can be problems. And then we also have people who are working at early hours and late hours, and we try to take, calls when people are maybe still at work, like on their lunch break. So like we understand that they might have some constraints that make it difficult to talk at different times. And then we try to when I'm interviewing people, I always ask them about the worst thing that's ever happened to their life. That whenever, despite their best efforts, the worst thing that happened, even though they tried hard. And I look for people who have had trouble, who have not been, who've not had a perfect, easy life. And so I think it's easier when you've had a situation that didn't go well, for you to identify with people who are going through a crisis at that time. And so that's what we look for.
Now, let me ask you a question a lot of people are kind of worried about these days, and that has to do with COVID, and particularly this vaccination program. There's been a lot of push by employers to have their entire workforce vaccinated. And, and it's understandable why some employers may be that way, because their workers may be, for example, unable to work from home. And so they have to come into a plant or have to come into a store or other types of public facing facilities. What advice do you have for workers who are genuinely concerned about the safety of this vaccination and don't want to take it? Do they have the right to say no, or can their employers terminate them if they refuse to take this vaccination?
So this is a really tricky question, which I always say, folks, I'm in a vaccine study, and I'm a person of color, and I understand the concerns, and I understand why people are hesitant to take the vaccine. And so I don't want to discourage people from taking the vaccine. I think you should take it if it's available to you. But having said that, there are people who cannot take the vaccine for a couple reasons. One is there are people who have medical conditions that make it difficult for them to take vaccinations. Those people will almost always qualify for an accommodation under the Americans with Disabilities Act. That's the first major category of people that are going to be exempted from that. You'll have to then, of course, request an accommodation, which would be excused from the vaccination policy. Okay. The other category of people that is a little less known and that can also affect people are those people who have, for a sincerely held religious belief, do not believe in vaccination. There are a number of religious sects that do not believe in blood transfusions or other interventionist policies by the medical providers. And those people can also seek an accommodation for their religious preference under Title VII. But for the vast majority of people, their employers can, but most employers won't, can require a vaccination. what we find is that very few companies are actually requiring a vaccination. Most of them are actually suggesting one, and some, like Kroger, actually just announced earlier this week, are saying, "Hey, we'll pay you if we get the vaccination. So we'll pay you an extra $100 if you go ahead and get vaccinated," to give people an incentive. And that is actually the better practice for employers, which is to give an incentive to provide the vaccination on site if people want it, but not to actually force people to take a vaccination that they may or may not want. And particularly for people in the African American community who have had a very, tenuous position with healthcare providers. And, I'm not far from Tuskegee, where they experimented on people and did not really take the proper precautions to make sure that people weren't harmed by their experiments. So I understand completely what folks are what's going on in people's heads, but the law sometimes is kind of on the employer side.
And if you could explain to us what happens if a person believes that they have been sickened as a result of being exposed to the COVID pandemic or the COVID virus while on the job, or alternatively, they've been sickened as a result of being either mandated or encouraged or paid to take the vaccination by their employer, and they have some side effects. What are their rights, and what should they do?
So interestingly enough, it really varies from state to state. But in the states that I represent people in, primarily your recourse on that, if you've been exposed at work, if you can prove you've been exposed to work, and with COVID sort of circulating throughout the community, that's a little harder than it could be. If it was, you got carpal tunnel, or some piece of machinery fell on you. But if you were exposed at work and through an outbreak, your main remedy is going to be, unfortunately, workers' compensation, which is never really a good compensation for what you would you experienced in harm. And what workers' compensation says is it's sort of a no fault thing. You don't have to prove that it's the employer's fault, but then they don't have to pay you fair market value for your injuries. And so that is going to be the biggest remedy that folks have. And you also should be paying attention to what's going on in Congress, and also in your state legislatures, because a lot of legislatures right now are actually passing laws that say you can't sue your employer, you can't sue anybody for what they did to you in COVID times. And so there's a lot of movement, especially in conservative legislatures, to remove the ability to sue based on people's negligence. And we've seen all around the country that unscrupulous employers, have been packing people into businesses and telling people they had to come to work, even though they knew they had active outbreaks of COVID.
And those are the liability, a company or employer liability protection shields that the Republicans, I remember, were pushing to have included in the stimulus package.
Right.
Did that actually get included, do you know, or no?
It did not get included in the last stimulus package, but there are similar bills going through state legislatures all over the country. So you need to make sure and contact your legislatures to make sure that you say, we don't agree with that, because I'm in a state where we have a lot of chicken plants, we have a lot of close contact industrial work. And those folks, and there was news coverage the other week about, people in a meat packing plant where they were taking bets on how many people would get COVID. They knew what was going wrong, and those folks should be held accountable. And the other thing too is sometimes there are claims. Let's say you work in one building alongside other people. There are what we call third-party claims, where if you weren't able to sue your own employer, you might be able to sue a different employer if you were exposed on their work site. And so, these liability restrictions are a real bad thing for employers and for individuals.
And can you share with me what exactly, let's just say, for example, if a person does believe that they have been injured and they need to, get help, what are generally the, kind of, 8, 1, 2, 3, 4 steps? I would say first step is to, go on and log on to abe.legal and, basically get a consultation with one of our experts, world-class experts like attorney Karim Fonteneau. But once, let's say, for example, they get on with Abe and they've scheduled a consultation, what are some of the things that you're going to talk with them about in terms of, again, getting the consultation? And again, you can go and check out the comment section. There's actually a link to actually click on if you are in this position right now and you want to go ahead and schedule a consultation. But what can they expect in that hour or so consultation with you, Attorney Fonteneau?
So two things. So one is what you should do if you feel like that you've been the victim of discrimination. And that is you need to complain. The first step always is to protect your rights is to complain, and you need to complain with specificity. It is not okay for you to just say, I think you're treating me unfairly. Or a lot of times people will say, well, I didn't want to play the race card, or I didn't want to play the sex card, or I didn't want to play the disability card. And that causes you to lose because you need to complain with specificity. And if you see that you're doing something and you're a man and a woman is doing the same thing and she's not getting disciplined for it, you have to call that out and you have to say specifically, this is because I'm a man, not because it's generally unfair. So you need to complain. The other thing you need to understand is whether you talk to an attorney or not, you have very short time frames to complain. Federal employees sometimes have 30 days, sometimes have 45 days. Private employees have as little as 180 days to complain about discrimination in the workplace. That is short. You cannot come back 2 years later and say, well, I think they discriminated against me because of my disability. Your case is gone. So you need to understand that. But one thing what we often do with folks, especially folks who are still working, is we will advise them about what they can do to preserve their claims. What do you need to document? What documents do you need to gather? Like, do you have your performance appraisals? Do you have your pay stubs? Do you have the things that prove that you were actually right and they're blaming something on you that you didn't do? Those are the types of things that you always want to have on hand before you make a complaint, so that if they happen to discriminate or retaliate against you and you get terminated, you have access to all the documents and the backup that you need to prove your case. Because it's a lot easier to prove it if you have the documents on the front end than if I have to go hunting for it later on.
And so let me ask you, what can a employer expect to get out of a lawsuit? Can they get the job back? Is there going to be, as they call triple damages, 3 times the amount of what they lost? What can they expect?
It depends on the kind of case. But let's say for a garden variety, race or sex or religion or disability claim, you're going to be able to get your back pay, which is the money you would have made had they continued to employ you and not discriminated against you. You're entitled to compensatory damages, which can be your mental anguish or other damages that you might have incurred. Let's say they terminated you as a result of that, you became homeless. And so there's a value in what that experience caused you. Or you had to get mental health treatment, or you had doctor bills that weren't paid because you were cut off of insurance, or moving expenses, job search expenses, those kinds of things. Those are compensatory damages. You're also, in theory, entitled to front pay or reinstatement. In the public context, reinstatement is a lot more common than in the private context. In the private context, the employer does not want you to come back. You probably don't want to come back, but the law says that they have to let you back. And so that's why you get front pay, which is money to compensate you for not getting your job back. And then there's punitive damages. In some cases, there are liquidated damages, which instead of you getting compensatory damages, they just double your back pay damages. So depending on what statutes we're talking about, there are very different schemes and damage caps. So you, in a Title VII case, no matter how bad your compensatory and punitive damages are, you can't get more than $300,000 for compensatories and punitive damages. You can get all the back pay that you earned, but you can't get more than $300,000. And so it depends on a lot of factors. But mostly the biggest thing that the employer is looking at is how much of your back pay. What did you lose in pay because you were not working for that employer?
And let me ask, how long does it usually take from the time they, book a consultation with you on Abe, and then after the consultation is concluded, how long will it take from that point to, let's say, get paid or get reimbursed for the lost wages that a person may have experienced?
So this is the part that's not fun. It can be a while. It depends though. So there are programs at the EEOC and a lot of times employers will see things that are bubbling up in the EEOC and they may take proactive action to settle a case, but that is not the commonplace. The thing to remember about EEOC cases for private employers are that the EEOC, when you file at the EEOC, they have a minimum of 6 months to resolve the investigation. You can't do anything with that lawsuit if it's an EEOC case until 6 months goes by on your own initiative. Now, sometimes the EEOC will kick the case out earlier than that, but the vast majority of cases take 6 to 9 months, sometimes a year at the EEOC, and that's just dead time. You're just waiting. Now, the EEOC picks a large percentage of cases, I won't say large, but a significant percentage of cases, and assigns them to mediation. And those can actually be resolved within a few months. That is not common, but it does happen. And then for the vast majority of cases, depending on what the case is for, you're going to file that lawsuit in court, and that's going to be several years after the EEOC takes it. So right now, I am looking at trying cases that I filed in 2017. So
what? 2017?
Yeah, for trial. Now, the vast majority of cases don't go to trial, right? So usually we'll file a lawsuit that the lifespan of it's going to be on average a year, 18 months, 2 months, if it settles. If it doesn't settle before we go to summary judgment and we go to trial, it's going to be a while. And then with COVID, it's actually taking longer because we're not able to seat juries to actually try cases.
So let me ask you two questions. One, with respect to that last point about the litigation challenges during COVID, but I think probably a more basic question for a lot of people who might be in this position is that, are you saying that basically they could be looking at a 4-year turnaround even before they get to trial? Then again, a trial that, maybe you can spell out how long the trial will take, and then, how long it will take to get the money. So is the first order of business to get a new job or find some other way to make some money to sustain yourself?
Yes. And in fact, if you don't go looking for a job, when you get to that trial, the other side will say you failed to mitigate your damages. And so you don't actually have any damages because you weren't looking for work. The worst things you can do for your employment case is to A, not look for a job at all, or B, apply for Social Security disability, because that's telling the employer that you weren't available for work. And so you're not entitled to damages. And so, yes, you do have to look for work. But if you aren't able, like let's say we're in COVID times and people are struggling and can't, you don't get paid the same amount of money as you did before, well, your damages still grow. They just grow slower. So, if you had a job making $20,000 a year and the only thing you could get is a part-time job making $10,000 a year, your damages are growing at $10,000 a year. If you were making $100,000 a year and it takes you 9 months to find another job, well, guess what? You've got a good bit of damages there. Okay, so you would know at that point that the time that it takes you to find a job is time that your damages are growing, but you still got to eat, and you still got to pay your bills, and you still got to look for work, and you have to document that you were looking for work.
And how about filing for unemployment benefits? Does that help or hurt your claim?
It actually can, a lot of times it helps your claim, because what happens when you file your unemployment is they send a document off to your employer. And in that document, it asks them, well, why'd you fire this person? And one of the best ways that we prove discrimination is when they told you that you were getting fired for X. Then they get to the unemployment office and they done said something completely different. Okay. They told you it was, the work slowed down. They tell unemployment you stole $200. Well, if the reasons are shifting, that's evidence of what we call pretext, a lie. And so that actually helps us to prove their case, because if they're making assertions to the government that are false, that helps to prove that they were discriminating, particularly if they can't back those assertions up.
And so are you basically advising people, first of all, to make sure that they, document everything that they're getting? But, sometimes the people are getting, let's say, emails on their company email address, but then after they're fired, then they don't have any access to that. I mean, what do you recommend to people in these types of situations?
Well, you can't hack in. So typically, I will tell you, as a person who's been terminated, if you've been terminated, you're going to be terminated. It's very rare that it's just out the blue. And so if you start to feel that itching feeling that maybe somebody is after you, you can keep copies of things that you normally had access to. Now, what you don't want to start doing is hacking into somebody else's email and stealing stuff that you didn't have access to, or a server or anything like that, because that's wrong. But copying yourself on emails, blind copying your home email, that's fine. Just understand that whatever you do, it's going to show up on their servers that you did. So don't go out there, making stuff up. And depending on what jurisdiction you're in, sometimes you can take people, like you're having a conversation with them and they're going to lie. You take your cell phone in there and record them. But that's very jurisdiction specific. So like, I know you can do that in Alabama, but there are some states where it's one party and you can't take them. And
if I take my phone in, do I have to, first of all, disclose that I'm taping, or can I just turn on my phone and start, recording the conversation?
It depends on the state. And there's a few states, and I think California is one, New York is another, and either Maryland or Virginia are one party states. So like, those are ones I know off the top of my head where you cannot tape people without their knowledge. But in other states that are two party states, and you need to check your state to make sure, in Alabama, it's a one party state. And if there's two people in a conversation and one of them wants to record it, they can record it and put it in there. Just put it. You don't have to know. You don't have to tell them. Now, there are other reasons, like sometimes people work in sensitive locations. Like if you're a government employee where stuff is sensitive, where you might have some rules or some laws that stop you from doing that. But for most private employers, if you check your state, you don't have to come in there and say, can I tape you? You don't do all that. You can just tape them. And a lot of times that will save. I mean, I've had cases where the employer was like, well, I never said that you couldn't work here because you had a disability. And here we have a tape. And they're like, well, we can't accommodate your disability. You got to be fired. Okay. And then they have to pay.
So let me ask you, because you talked a little bit about the federal employees' rights. How do those vary? How does the EEO process vary, and then the MS? Keep all mixing up these acronyms. Merit System Protection Board, right? MSPB, right? What are those two kind of processes like?
So the MSPB oftentimes will run side by side, but if you have a termination or sort of a major a removal, a suspension, a furlough, a demotion, a termination, then they can kind of adjudicate that. But then there's also the EEO process that deals with issues of discrimination. Okay, so where it's based on one of the protected categories, there is a process, and each one of those two has a different process for you to take in order to get your concerns addressed, and they're short. So if you feel like that you've been demoted, you got like 30 days to go say something to make that complaint. If you feel like it's racial or sexual or because of your disability, you got 45 days to initiate informal counseling. And once that counseling goes on, that'll progress, and then they do an investigation internally and try to resolve it with you. And then if it can't be resolved, it goes to a formal complaint, and then there goes to agency decisions, and then there goes to the EEOC, and there's a whole set of processes that happen after that. So, and then ultimately, even if you don't like what happens at the EEOC, you can go to court in federal court. So the reality is a very, very long process for a federal employee. And the only part that has to be quick is the employees. And so you really have to get in early and make sure that you are complaining and getting your concerns documented early.
Now, let me just ask you again, based upon your work both in civil rights, employment law, and also federal EEO and federal Merit System Protection Board actions, how is COVID impacting all these types of cases? You alluded to it earlier, but let's just kind of dive into it so people can know what to expect.
Let me tell you, COVID has made employment law very hot, right? Because so much of how COVID affects us has to do with employment. We have people who are now working at home for the first time, and people who are trying to spy on folks at home. And you got people who are sick or they have disabilities and they can't come to work and they need accommodations, and their employers who are feeling stressed say, I can't give you an accommodation. You have people who are seeking leave because they have COVID and they're being fired afterwards. You have companies that are downsizing because COVID has caused them a financial hardship, and maybe they're picking older people or people of color to terminate as opposed to looking at skill set or, rank in the job. There's so many things this is affecting. And then you also have parents who are scrunched because they can't send their kid to school. And so they have a lot of issues. And so there aren't very many areas of law as severely affected by COVID as the employment law context. We have been busy. I mean, I've had everything from people who have been denied accommodations during COVID to people who were denied their family and medical leave during COVID. And it's all starting to bubble up now, and it's only going to get worse as the economy gets worse.
So this has been a really interesting conversation. I mean, honestly, I really think that you are, like we state on our platform, a world-class lawyer who is really bringing her real-world experiences to bear in terms of employment law, equal employment opportunity law, civil rights law, federal employee EEO and Merit System Protection Board law. Let me ask you to kind of give us, as we conclude, what your thoughts are about this current administration and what people can or shouldn't expect from the current government in terms of change. Are you likely to see the pendulum shifting to be in favor of workers, or is it going to be pretty much business as usual?
Look, we're already seeing the changes, which we're seeing, the president asking for a $15 minimum wage. That's going to help employers tremendously. And so those are important things. I believe, obviously it's yet to be seen. But some of the things that will change will be on the legislative front. The EEOC kind of has a commission, and they're kind of set. And so they kind of operate off on their own. But I do think that where there are opportunities for this administration to help, They will. And one of the other ways that they're going to help is, to the extent there are any judge vacancies that come up, they are looking actively to appoint people who are from the criminal defense bar, the plaintiff's bar, and also public defenders and people who have done civil rights on the plaintiff side, so that they can kind of equal out some of these anti-employee, anti-civil rights victim rulings that have really hampered our ability to work. But I'll say this, one of the things that the prior administration did was normalize people being very vocal about their racism, their sexism, and their disability and their ageism, right? It was okay to say negative things. And so what we're seeing is people were being a lot more open. And so it really wasn't, the case law was still really clear that what they were saying was inappropriate, even though we had a bad, we didn't have a pro-employee administration. So the law is still there when you have the very clear cases. But what we should be looking for the new administration to do is to expand the law and do a couple things. One, for sure, we should be pushing people to end qualified immunity. That is the law that makes it very difficult for people to recover when government workers beat people up, kill people, maim people, jail them for no reason. And we should also be looking for that minimum wage protections. And probably we should be looking for some LGBTQ codified protections in the statutes, although the Supreme Court has been very helpful to the people in the gay community of late. So I think it's good. Typically, when we have Democrats come in, workers benefit. And I also start to look at collective organizing, collective bargaining. Right now, there is a campaign against Amazon right here in Bessemer in Alabama, where employees are seeking to form a union for the first time against Amazon in the U.S. And so you'll see the National Labor Relations Board supporting those employees in their ability to collectively organize. And so, I think now is a good time for employees, and hopefully we'll see better.
And from, again, small employers, right, or even large employers who are, looking for ways to protect, themselves against worker, complaints or EEO actions. What advice do you have for them?
Yeah, so it's important, right? Like, I think it's important for people to understand and put in good processes and procedures. When I normally am suing people is because they have a policy and they don't follow it, or they have no policy at all. And so what happens is when you don't have a policy and there's a vacuum and there's a lack of training, what you have is individual people operating off the cuff, and those off the cuff decisions are ones that cause liability. And so poorly trained, poorly documented, and poorly executed employment decisions will cause litigation every time. The other thing too is pay your people fairly, listen to them, listen to both sides. Don't just make knee-jerk decisions, and check your own possible biases that you have at the door. And if you're sitting here telling people that they're moving slow and maybe you should retire. Well, that's ageism, right? You may not think it is, but you're making these comments and people are perceiving that. And so I think it's really important for people to check that and not to be so, defensive about the things they don't know, right? If you feel like you can't be racist or no one can tell you anything and it harms your psyche because somebody says that to you, what you're going to do, you're going to retaliate. And so people just need to kind of pull back a second, have an HR that really does listen to employees. Make sure you get good statements. Make sure you document performance problems. And those kind of things will head off litigation, because I'll look at a file and see, well, you got written up 5 times. Did you do this? Yeah. Did you do that? No. Did somebody else who was white not do that? And if I see that the paperwork's the ducks are in a row and my potential client can't find a reason why a white person was treated better or outline that, then I'm not going to take that case. But if your documents are in disarray and your people, are looking like they have been treated different than other people, well, as they say out in the West, giddy up. Let's go.
I think that this has been a tremendously important and very rewarding conversation from both the standpoint of employees, workers, as well as employers. One group that we didn't cover, and I want to just kind of dive into before we end, is the rights of folks who are independent contractors. We know that in this kind of gig economy, you have people who are not employees, but who are working in some of the same conditions of employees, and they may be facing either discrimination or wrongful termination. What are their rights?
So interestingly enough, there's two questions embedded in that. One is whether or not they're really an employee or a contractor. And your employer doesn't have the right to just unilaterally say, oh, you're a contractor, you don't work for me. You have to meet a test to determine if you're an employee. So if you're going to their job, wearing their uniform, working their hours, using their equipment, and you don't normally do this anywhere but their work, you're probably an employee, whether they pay you with the 1099 or not. So that's number one. But let's say you really are a 1099 employee. In that case, there's really only two bases by which you can recover. One is for a breach of a contract. So if y'all have a contract and they don't live up to their end, then you can deal with that in that way with the breach of contract claim. And number two is Section 1981, if you believe that it's based on your race or your national origin. So if they treat you as a 1099 employee differently than they do white 1099 employees, you have a right to sue under Section 1981. And so, because Section 1981 deals with the right to contract. An employee relationship is a contract relationship. So it does not matter whether it's a 1099 contract employee or a traditional employee contract employee. So in those cases, you can still sue for racial discrimination in contract.
Well, again, I think that if anybody was a little less than informed about the issues of employment law, equal opportunity employment, as well as federal employee rights, if they listen to this podcast, they're going to really be much more informed. And I really am so grateful to you, Attorney Fonteneau, as you have shared your time with all of our listeners and our viewers. And again, for all those viewers who have follow-up questions, we're going to make sure that Attorney Fonteneau subscribes herself to Abe. So then when you have your questions, then she'll be informed of them, and then you can get perhaps your questions asked directly. But of course, if you would like to have a confidential consultation from the comfort of your home without having to leave, you can do that by, again, going and checking out abe.legal. Again, the link is in the comments section. And we really are very grateful. Attorney Fonteneau, any last thoughts as you conclude this wonderful conversation?
Well, just thank you for having me. And I hope everybody stays safe and has a good 2021 and it gets better than it was before.
Again, thank you so much, Attorney Fonteneau. This has really been a wonderful conversation, and we look forward to having more conversations with our world-class lawyers. This is Attorney Talib Karim with Abe Legal. We are, again, very grateful for this time to spend with you. If you have any questions, don't hesitate to check us out. Don't hesitate to subscribe to this channel. Don't hesitate to put your questions here, and don't hesitate to like this program. We are here available for both employees as well as businesses day and night. At abe.legal. This has been a great conversation. We look forward to joining with you next week. Until that time, have a
Thank you for having me.